Welcome everybody to a very unusual DEFCON. Lots of things are different. Lots of things are staying the same, including, as always, the open organization of Lockpickers, Lockpick Village. We're so glad you're here. We hope that you can learn some things, have some fun, walk out more fired up about hacking and lockpicking than you arrived. My particular part of this today is Law School for Lockpickers. What even is that? Well, by way of background, I'm Preston Thomas, a former board member of TOOOL. I'm a licensed attorney barred in the District of Columbia and in California, which is importantly different than barred from DC and California. I've done this talk before, including at DEFCON, but 2020 has brought this topic into a new light. Security research of all kinds, from hacking, reverse engineering, social engineering, lockpicking, these all rely on civil liberties of an open society with rule of law. Hacking is by nature subversive. Lockpicking is no different. So, like journalists and priests and security researchers, our job is to comfort the afflicted and afflict the comfortable. We can do things many people don't understand. For certain types of people, encountering something they don't understand makes them nervous, irrational, maybe even angry. I should know, I've worked with TOOOL for almost 10 years and been a lawyer for longer. And when people get nervous, irrational, or angry about lockpicking topics, it often ends up on my plate. Falls to me to explain it. I've had this particular conversation hundreds of times. So this talk today, it isn't for you, it's for me. I want to recruit all of you into my crusade to push back on the tide of bullshit about laws and lockpicking and how the two interact. I'm tired. I want to be done talking about this, but people won't let me. Help me, please. Let's do this. To begin with, I am a lawyer. I am not, however, your lawyer. This is so not legal advice. The only advice I'm going to give you today is don't get your legal advice from a guy at a con. Also, my opinions are my own. They don't represent TOOOL or anyone I work for. Standard disclaimer. Law and Order was a great show because half was the cops and half was the lawyers. For the law part, you can just Google what the laws are in a specific jurisdiction or how to talk to a law enforcement officer. There's great stuff on YouTube about that. This is not that talk. This talk is more the second part, the order part, about why lockpicking laws are the way they are and what it means for you as a practitioner dealing with lots of non-practitioners. Everyone has legal theories about lots of parts of daily life, not just lockpicking. Most of them are workable, some of them are nonsensical, some of them are absolutely bananas. And where do loopy legal theories tend to come from? Armchair lawyers. Armchair lawyers everywhere with their good old University of Wikipedia law degree. And their specialty area is something I like to call folk law. These are these ideas about law that everyone seems to know, but no one really seems to know where they came from. This is, I want my one phone call, or if you ask someone if they're a cop, they have to tell you, or I don't have to pay income taxes because I live in the free state of Jefferson. Because of folk law and all the people opining about it and spouting off about it, Googling about lockpicking laws on the internet is worse than Googling about that weird rash. So let's get real. Today, let's do this law school style. We're going to be concrete, specific, and clear in how we use words. Let's start off this law school for lockpickers by building a law. Let's build a criminal statute called the possession of burglary tools, because that's almost always what we're talking about when we're talking about the legality of lockpicks. Criminal laws are constructed of elements. These elements are what need to be proven beyond a reasonable doubt before someone can be legally found guilty of a crime. In the case of a burglary tool statute, there's usually two elements. Possession is physically having a tool or device, including lockpicks, and intent means criminal mindset, i.e., you intend to do something that is against the law. You can call this formula possession plus intent. Now, intent is difficult to get at. It's in your head. It's not something the court has access to. So typically in a court of law, it's shown through circumstances. In other words, part of the district attorney's job is to show circumstances that make it beyond a reasonable doubt that a person had crime in mind at the time they possessed lockpicks. No circumstances, no intent, no crime. In most states, it's as simple as that. mere possession of lockpicks without any circumstances indicating unlawful intent, not a crime. You look across, you can see that is the vast majority of states. We color them green just because it's nice, it's soothing, it sends the right message across. But what about those shadowy places, you say, in your best Jonathan Taylor Thomas 1994 Simba voice? Remember how I said intent was really hard to get at? The court can't know what's in someone's mind. So who better to provide evidence about the state of someone's mind than the person themselves? That is the thinking behind that minority of states that just throw up their hands and say, you tell me. I'm looking at you, Virginia, Ohio, Mississippi, Nevada. Laws change over time, but they pretty much solidified down to these four as having the possession plus intent formulation. So these states, they write their burglary tools so that possession of lockpicks is prima facie evidence of intent to commit a crime. We'll talk about prima facie here in a second. Here's an example from the Code of Virginia. For those of you who like to follow along, this Criminal Code 18.2-94, the possession of such burglarious tools, implements, or outfit by any persons other than a licensed dealer shall be prima facie evidence of an intent to commit burglary, robbery, or larceny. So let's talk about that prima facie word. It's not law school without some Latin. Let's dive into it. Prima facie, Latin literally means on first face, or on first impression, you can think of it. In plain English, that means if I didn't know better, I'd say something. I'd say you're up to no good. Turning that back into legal language, that's referred to as a rebuttable presumption. It's a presumption because it starts off set to true, default value true. It's rebuttable because that default value can be changed, which means the ball is in your court. Or in more colloquial terms, prima facie means splaining. And I put this GIF up there, and I'm increasingly surprised how few people know what it's from. If you don't recognize this GIF, congratulations on your high school graduation, I guess. Okay, so people will often say, but I have a presumption of innocence, but my Constitution, I've got rights. And you're right, you do have rights, at least for the time being. But the presumption of innocence is not one of the rights that's guaranteed in the Constitution. You can read it, it's not that long. You should read it, it's worth the read. And one of the things you'll notice, there's no presumption of innocence mentioned in the Constitution. It flows indirectly from the 5th, 6th, and 14th Amendments. Coffin versus United States is one of the first cases you study in law school. And that shows how, even though it's not actually in the text, it was discovered as a necessary implication of the rights guaranteed explicitly in the 5th, 6th, and 14th Amendments. More importantly, though, this formulation of burglary law just won't be challenged in court because it's too much of an edge case to ever make it to trial. There's two things DAs hate. They hate crime and they hate losing cases. And because this formulation, even if it is arguably unconstitutional or might be, it'll never get tested because if it's such an edge case that you might be able to make a constitutional argument, the DA will shrug his hands and throw it out. He doesn't want to go down that route. That's not what his job is. He's got much bigger fish to fry. So these kinds of problems where the law is a little unclear and common sense doesn't seem to quite match up with the way the law is written, that's why humans are in the loop. There's district attorneys with prosecutorial discretion. There's judges sitting over each trial. They're specifically there to handle exceptions where the law as written doesn't quite match up with the facts on the ground. So even if you might be able to have a constitutional problem with this formulation, know that it will probably never come to trial because no one's going to care enough about a fact pattern like that to actually push it. Now, there's kind of a sense of boo hiss about these states that have possession implies intent formulation. And a lot of people think, oh, they're just wrong, or they're nonsensical, or they're anti-hacker, anti-lockpicker. But if you look at actually what their thinking is, it begins to make a little bit more sense and you have more sympathy for them. So I decided, let's look at some of them. First of all, I didn't know what the Nevada flag looked like. I had to look that up just for this presentation. Here's what Nevada decided. is they said in a case 1965 that is still good law, they said it is consistent with all the constitutional protections of accused men to throw on them the burden of proving facts, particularly within their knowledge and hidden from discovery by the government. This is an illustrative example of the kind of reasoning that motivates possession implies intent states. You don't have to agree with it, but you can see what their thinking is. If we're having trial and the goal of the trial is to find out what the truth is and whether someone is guilty, and that person has the information they say is relevant to the case, they should be able to provide it. If they have it, then the least they could do is show it to the court. It kind of makes sense. It's very simple. Maybe it makes some of our civil liberties impulses a little squeamish, but it's not unreasonable, especially when you consider the one that we collectively like a little bit better, which is the possession plus intent formulation, the more liberal version. So why shouldn't we imply intent? And here's an example from the District of Columbia that shows the kind of reasoning involved in arriving at the idea that possession plus intent should be the proper formulation. And what they say is, and this is great close parsing by the judge. He says, although the sledgehammer, axe, and hacksaw, which the appellant had, quite clearly can be used criminally, they also may, and for the most part are, used for legitimate purposes. Since the mere fact of possession of such implements has no relevance to guilt, it may not be made the occasion of casting on the defendant the obligation of exculpation. In other words, unless what you're carrying are literally drugs or something else that's similarly illegal just for existing, then the cops have to introduce additional facts to overcome the statistical likelihood that you intend to use them for a legal purpose. Most people carrying axes, sledgehammers, hacks, hammers, etc., are using for legal purposes. So why, in this case, would we infer that they're using it for anything other than legal purpose? When you walk through it like that, it's kind of tortured logic. You have to suddenly appreciate the people who say, hey, you know what? It's probably what it looks like unless you tell us otherwise. I have a lot, after doing the research for this, I have a lot more sympathy for the jurisdictions that decide to throw up their hands and say, you tell us. I know some of you in the back are saying, hey, aren't there different types of intent under the law? Yes, but that's not relevant here. Any intent will do for this particular formulation. Now, this kind of close parsing and close analysis of the way laws are written and what's the meaning behind them leads to some really funny outcomes, including my favorite lockpicking case. It turns out I have a favorite lockpicking case. We are once again back in the District of Columbia. This is a DC appeals court, still relatively recently from 2014. In re JW means there was a minor involved. So some kid under 18 got nicked by the cops. Funny circumstances. Here's what happened. JW was arrested red-handed trying to steal a Vespa with a pair of bolt cutters. He was charged with possession of implements of a crime, which is the usual statute that applies to lockpicking. Both elements are satisfied, no question. He's sitting there, middle of the night, by the Vespa, bolt cutters in hand, definition of caught red-handed. Absolutely possession, absolutely intent. However, there's an inartful drafting of the statute because the statute specified, doesn't usually specify, but in this case it does, it specified tools for picking locks. A meticulous appeals court judge observed that picking a lock is generally understood to require skill rather than brute force, and to turn the lock without damage to the lock. He literally went and looked up the definition of picking a lock in the dictionary and came back with that and entered it in the record. As a result of reading the statute across from the definitions, it was, the judge concluded, not physically possible to pick a lock with bolt cutters, nor is it legally possible to convict JW under the statute as written, because try as you might, those big old bolt cutters will not fit into the lock and turn it in a non-damaging fashion. Conclusion, no possession of tools designed for picking locks, and JW goes free, and anyone who complains about that gets to go back and write the statute a little bit more carefully. I think that is a great example of a judge carefully parsing the statute, holding the state to what they said they wanted, and then telling them if you want something different, you have to be a little bit more careful. Another thing I like about this is this means that we have it on record that all those savages and reprobates at conferences who destroy the locks and tie the lockpicks into pretzels are not, legally speaking, picking locks. So here's the part that I think a lot of people show up for. The number one absolute main area of shouting and nonsense regarding locks and lockpicking is speculation on breaking the link between possession and intent. So let's talk about it. This is in those states where possession implies intent, those minority of states. Well, what can we do to protect ourselves? There's a thought that these are the places where lockpicks are illegal and we have to be on our guard and we have to have an answer ready. So what do we do about it? And something that often comes up is have a card, have some kind of self-made card or a more professional card. Poof, problem solved. This is that fantasy of holding it up to the officer and say, "Don't worry, officer, I have a permit for this." That couldn't be further from the truth. There is no such thing as a get out of jail free card, because they're absolutely allowed to have that conversation with you. And by the time you're having that conversation, it is not in your interest to try to avoid that conversation. Instead, I want you to think of, if you're having a conversation about lockpicks with a cop, it is in your interest to engage in and expand in and own that conversation rather than trying to flash some kind of card and avoid it. The TOOOL membership card, which is forthcoming, contains a few carefully crafted paragraphs to help you achieve a productive tone in that conversation. Essentially, act as a conversation starter. It's a way to help you have the conversation effectively rather than avoid the conversation. It explains that TOOOL is an organization that exists, that recreational locksport is a thing that exists, that the holder of the card is a member of TOOOL, and it gives a gloss on the general state of overall laws. It doesn't overplay its hand. It basically digs down to the idea that what we teach and what we do at TOOOL is legal everywhere in the United States by definition, because lock sporters and researchers have a legitimate use for their picks, and they follow the two rules, which are quite famously in TOOOL. Don't pick a lock that you don't own. Don't pick a lock upon which you rely. If you're following those rules, then you don't fall afoul of either formulation of the state law, no matter where you are. So that helps set the right tone. If you're a conscientious locksport practitioner, don't hide them, don't lie about why you have them. Essentially, don't act guilty if you aren't guilty. People will sometimes come to me and say, "Preston, that's all well and good, but what if I'm doing this or that or the other thing? What about this circumstance?" And what I always tell them is, if what you're doing is a crime, then you're literally doing what the crime of possession of burglary tools says, and you have no basis to complain. If, on the other hand, you are not, and you're practicing good lock sport ethics and you're following TOOOL's rules, then you can be safe in knowing that what you are doing is legal in every state in the union, and you have a card to help explain that concept to anyone who's asking. Now, we are very serious about keeping our members and our friends on the right side of the law. Nonetheless, and I want to emphasize, this is not legal advice. This is just wisdom that any person in a society should know. Let me give you a rule of thumb. Call it the one crime at a time rule. If you choose to break the law, don't break the law while you're breaking the law. Don't accidentally turn a legitimate hobby into an indictable offense by carrying lockpicks along on a time when you shouldn't have them. In the words of legal philosopher William Smith, in the matter of Earth versus Giant Bug, 1997, don't start nothing, won't be nothing. I have heard from many police officers, many different jurisdictions. I've asked them, I have been on public transit sitting there picking on my practice locks, and I've said, "Hey guys, I'm sitting here picking locks. I'm pretty sure that's acceptable. Do you have any problem with it?" And they say, "Planning on picking locks on the train? Are you planning on picking locks on the airplane?" They don't care. They have actual crimes to worry about. If you're sitting there as a law-abiding citizen doing something that's not bothering anybody, it's not worth their time. So don't be nervous about it, and don't worry about ignorance of the law becoming a problem for you, because you're willing to have that conversation. Another area that people oftentimes ask about is federal law, particularly TSA. DEFCON is one of the most common sources of that question, because people say, well, I just bought lockpicks, but now I can't take them on an airplane. Well, it's not a factor, because it is literally, I've lost a T somewhere. I've got to fix that. But it is literally not a factor, because TSA has a set of things that they're looking for and a set of things that are not on their list. Because a lockpicking tool is a non-sharp tool, less than 7 inches, it's carry-on approved. It's simply not disallowed, which means it's allowed. And don't say this to TSA if you're having that conversation, but the locks on the cockpit doors are not even pin tumbler locks. So all the more reason for it not to be on their list. After years and years of asking them, we've got a Twitter conversations from a bunch of different people here. Their agents finally added lockpicks explicitly to their can I bring my self-service site on the website. So if this is a concern for you and you would like a little extra backup, then feel free, go on the website, take a screenshot, print it out, throw it in your lockpick kit. I've done it. I know a lot of friends of mine in TOOOL have done it. We carried around our lockpick kit for years and years and years until it got ratty and torn up. Then we threw it away and we never used it. Once again, because TSA agents just don't care. But remember, like anything that you want to carry on a plane, the TSA agent gets the last call. So be polite, be friendly, be patient with them. Whether you're doing an opt-out or bringing something unusual through carry-on, just make sure you have enough time to have the discussion without being rushed or being flustered. Yes, I like opting out. There's good ethical reasons to it, even though sometimes it's a pain in the butt. If I'm in a hurry, I don't want to miss my flight, yeah, I'll go through the scanner. Carrying lockpicks is likewise. If I'm really in a hurry, I'll just check them. But for the most part, I like carrying them on, A, because I know where they are, because they're valuable, and make sure they don't get broken, but also to make sure that I'm practicing what I preach and telling people, yes, it's not a problem. And on the rare occasion I have those conversations, then I can make it that much easier for the next person coming behind me that's bringing lockpicks. One of the best pieces of advice I get when I got in law school, when you're having conversations like this, is always try to seem like the most reasonable person in the room. Seem like the most reasonable person in the room. If you seem like you're prepared for the conversation, if it's not a surprise for you, then that really helps them be that much more calm about it. As a last resort, many airports will give you the option to mail something home rather than trashing it. Another great option if you've got time to take advantage of it. Here's what I do when I'm taking my lockpicks through an airport. This is my bin on the inside of security at San Francisco. Note the gigantic bag of lockpicks, including the fuzzy handcuffs right on top, just in case anyone wants to get curious. That's all totally legal, as are the Bogotas in my wallet, which is there on the right. No one ever notices that. Ironically, the illegal thing in the picture is that little bottle of Kraken rum there. I totally did not know that you were not allowed to bring the little bottles through security or onto the airplane. You're not allowed to provide your own booze. So yes, there is something illegal going on in that picture. No, it's not the lockpicks. Yes, it is the booze. A note on having fun with TSA. I like putting the handcuffs on top because if they're going to open up the bag, I like to put a smile on their face. It gives them the problem of, do they dig around the handcuffs? Are they allowed to pick the handcuffs up? This is, a dildo versus your dildo territory. As long as they're going to have the conversation, there's no reason we can't make it a little bit fun. And before you ask, yes, handcuffs are also legal, are also permitted in carry-on. Lots of good reasons for that, including security officers and police officers that always travel with handcuffs. A few years ago, Lady Gaga brought her own fuzzy handcuffs, and there was a bit of a hullabaloo about it, but they were, of course, allowed on. So fun lockpick tricks. Just carry fuzzy handcuffs as well. It helps set the conversation on the right mode. A comment that I got from Max, who works with TOOOL, He said, always remember that you can help the conversation along by giving some framing. So if you see your bag of lockpicks go through the x-ray and the person's eyes kind of light up and they shunt it off to the side for further inspection, wave at the guy as you're walking over. Start off the conversation just right. I see you've got my bag of lockpicking equipment there. I do this, that, or the other thing. I do lock sport as a hobby. Inside, you will find the following things. You can help them get in the right frame, and there's kind of an art to helping them arrive at their own conclusions rather than dictating to them, and which in a way that might make them suspicious. So don't avoid the conversation. Welcome the chance to practice the conversation. It's almost always no big deal because, again, it's a non-sharp tool, less than 7 inches. And we will pass handcuffs and we will go to the rest of the world. And people often ask me now that I've talked about the United States, what about the rest of the world? And the answer is the rest of the world does not differ materially from the United States for the most part. Everywhere around the world, you'll find countries and individual jurisdictions with both formulations. The most common formulation is possession plus intent, but there are some places that have possession implies intent. So Commonwealth, UK, Australia, New Zealand, Canada, they're all legal. Some of them are possession plus intent. Some of them are possession implies intent, but none of them make it strictly illegal. Netherlands, as we know, TOOOL having started in the Netherlands, perfectly legal, and there's quite a robust culture there. Israel, a little bit more tightened down. They're definitely in the possession implies intent camp. And I'm given to understand that in China, they're fairly illegal, but like many things in China, it depends on who your patron is. So yes, when TOOOL goes to China, we do take lockpicks with us. We teach lockpicking there, and we get it all cleared through the proper authorities, and we haven't had a problem yet. Now, there's one last thing that needs to be said before I round this out, which is 2020 is in some ways different than other years. In some ways, no different than it ever was. We're just learning more about it now. The Black Lives Matter movement has really drawn a lot more attention to the interaction between young Black people, people of color, and law enforcement. And it wouldn't be right to finish this talk without mentioning that all the advice I gave works great if you are a white, reasonably well-educated male lawyer. Does it work as well if you're not some of those things? And the only answer I can tell you is all the principles remain the same, but it is absolutely hard mode. It's no surprise that you might have to speak better, understand better, make yourself heard better to get the same results. And there's nothing that I can say to make that okay in this talk or to really give a lot of insight from a perspective other than mine. But I do want to acknowledge that the law is the same and many of the same principles apply, but it's hard mode. So that is the laws of lockpicking. I understand as we end this, I'll have a chance to take questions. So for anyone who has questions about lockpicking in the US, around the world, who has stories they want to tell, who has hypotheticals that they want to get insight on, I would be happy to share them. Mostly, thank you for showing up for this conversation. Happy lockpicking. Look forward to seeing you around. Cool, here we are.
Yeah, Needles will let you know.
So currently no questions have come through, so as previously mentioned, if you have any footnotes you'd like to add, now is an ideal time to do so.
Yes, certainly. So the main footnote is that lockpicking is one of those funny hobbies that you don't need anyone else to do. You can quite happily do it completely and to its full extent in your basement by yourself. So an organization like TOOOL, which is an outreach organization for a solitary hobby, we have a very interesting role because we are taking that hobby out of the basement and bringing it out to people in public, in institutions and at events. So we run into these questions a lot, and it's part of the fun part of our job
is familiarizing people with something that normally they have no experience with. So I've had the conversation about, are lockpicks legal? Are they allowed? Are they moral? So many times, and I just have to remind myself that even though it's the 100th time that I've had these conversations, for a lot of people, it's the first time they've had this conversation. So patience with the issue, a sense of humor, a willingness to engage with it. And at DEFCON, many a year, I have to remind myself not to yell at somebody, because if they've come all the way over to the Lockpick Village to tell me that lockpicks are illegal, at least they've put in the effort and they actually have interest in it. So I have to treat them at least with the same respect of going all the way across the venue to have that conversation. They've come all the way to me. I should be willing to go to them. So it's a constant reminder. And if you're a Lockpick practitioner, but not high up in leadership of TOOOL, you may not have the conversation quite as often, but we want you equally well equipped, in part so those conversations don't make it all the way up to me and to the board and to TOOOL leadership. We can deal with them at the individual levels. So if you're here and you've sat through the talk, obviously you're pretty well equipped to have that conversation right now. But if you have particular questions, I'd love to hear them. I always learn something from you guys' experiences on the street. So feel free to throw questions in the Discord or in the Twitch. And I think Needles is the master of all of those, and we'll make sure they can get conveyed to me.
Yep, so we actually already have a question. So Electric Starshine asked, is there a global registry of where picks are and aren't illegal that people can check?
So the question of whether there's a global registry that people can check, there isn't. We do our best to keep the United States one up to date. And that's hard enough because state laws change and interpretations of state laws change fairly regularly. So keeping that fresh is enough of a challenge. Interpreting national laws and even just reading all the different languages is above what TOOOL can do. And so I don't know if anyone's put together a gloss on, I don't know of it. It would be quite difficult. It should be done. And TOOOL would be the natural people to do it. So this is probably something we can crowdsource, of asking the local experts, what's the law that, as best as you know it, how do you know that, and trying to keep that up to date. It will never be legally reliable, but it'll be always a useful rule of thumb. So if you have ideas about that, shoot me a message. I'm at PNT in DC on Twitter. We can absolutely start compiling that. Even if it's not perfect, it'll be better than anything that exists right now.
Okay, so someone asked kind of a question. So have you looked at any tie-ups with official organizations like Master Locksmith Associations UK?
You said, have we looked at any tie-ups
with official organizations?
Is that what you took from that, Needle?
I'm just reading it to you verbatim. So it says, have you looked at any tie-ups with official organizations like Master Locksmith Associations UK?
So I'm going to interpret that question as, have we considered partnering with other lockpicking organizations to have more effect? And we have great relationships with a bunch of different lock sport organizations and also with professional lockpick organizations. Like in the United States, ALOA is the professional organization versus TOOOL is one of the hobbyist organizations. We like to keep good relationships with them, but we do very different things, and we try not to tread on their territory. So there's not a lot of co-branding or co-eventing because we have such different spaces. They tend to support us by being friendly to the hobbyist community. We tend to support them by not holding ourselves out as teaching professional locksmithing skills. We teach amateur and hobbyist lock sporting. So parallel tracks, working on similar ideas, but not a lot of professional overlap within the organizations.
So Varsil asked, does TOOOL do any advocacy to change bad rules? Alberta implemented a ban on lockpicking tools, for example, and so I'm wondering if there are any lobby/advocacy groups.
Hey, that's a great question, Varsil, and one that we've encountered. In fact, we've had to explain to the tax bureau of Vegas, that yes, TOOOL is allowed as any organization to engage itself in the political process without actually being an advocacy organization, lobbyist organization. We are private citizens with a First Amendment right to engage in the political process. And TOOOL does hold itself out as being willing to do that. And on occasion, we've stepped in and wrote clarifying emails or clarifying letters. It's been a long time since we've gotten involved in the political process, mostly because the news has mostly been good rather than bad of organizations writing regressive lockpicking policies. So something like Alberta, that would be right up our alley. I hadn't heard about it until you mentioned it right now. But TOOOL, contacting the right people and explaining to them that we're a hobbyist organization and we have members that would be affected by this, and we don't think this is actually what you intended, let's talk about it, is exactly the kind of thing that TOOOL is willing and able to do and that our members expect us to do. So thank you for letting me know about that. We have members in Canada. I don't know about Alberta specifically, but we have members in Canada that could probably speak to this and help make help us get involved if people wanted us to. So thank you for the heads up on that. I know we have members of the board on this call already. They might add that to the list and see if that's something that we'd be willing to write a letter on. We have all the text. It's just a question of who do we address it to. So thanks for the heads up. That's a great idea.
Thank you for your clarification on that. Touching on the very last bit of your talk very briefly, how do you see the regulations regarding lockpicking affect maybe coming into play with the recent protests that have happened? If I remember correctly, in one of the cities, a part of the city was claimed as a autonomous zone. And would anybody with picks in that zone, for example, be grabbed as, would that be taken as prima facie evidence of committing some unlawful act, in your opinion?
Yeah. So there's a couple of things to unpack there. The first one is to remember that under most circumstances, the lockpicks themselves aren't the crime, especially because they're small and they're not visible. So what they end up being is an augmentation to another crime. If they've got you for something and they're unhappy with you and you've got lockpicks, that's something else they can throw on there, and that's just standard police negotiating tactics for wanting to get a plea bargain, wanting to get you to talk, to confess, to discuss. They'll throw on lots of things. So that's why you get trespassing and breaking and entering and inciting a riot and conspiracy to. Anything they can throw on there improves their bargaining position. It's a negotiation. It's kind of a grim negotiation, but it's negotiation. So that said, if you're showing up to something, to a riot, to a protest, if you're expecting to be in a position where you might be getting in trouble, even if it's good trouble, you can limit the amount of trouble you're getting into by taking precautions ahead of time. Leave things at home that will complicate your life. Don't bring your weed. Even if weed is legal in the state, it's a complication. Don't bring your lockpicks. Even if the state with helpfully written lockpick laws, don't bring it. Simplify your life. If you have a knife and you're not sure if it's under or over the limit, don't bring it. Again, a lot of this starts with law, but it comes down to common sense. And so the answers can be sometimes unsatisfying because there are no magic bullets. Life is messy, and the writing of laws and the enforcing of laws is messy. So for something like the Capitol Hill Autonomous Zone, it's a known area where there's going to be questions, there's going to be gray areas, there's going to be difficulties. Show up, do your thing. If protesting is your thing and you have a way to contribute, go do that. But if lockpicks are not going to help you there, then don't bring them. If they are going to help you, you should think very carefully about how you expect them to help you. That goes to the comment about handcuffs. Yes, getting out of handcuffs is a cool trick. It's fun. It's a fun party trick. We use it for games and competitions at TOOOL all the time. No, getting out of handcuffs is highly unlikely to improve your life if a police officer put them on. Even wrongly so, escaping itself then becomes a crime. So I said repeatedly, this is not legal advice. This is just practical advice. Don't that's just not the place for it, is what I would say. There's lots of other civil disobedience you can do there if you're showing up something like that. There's bigger fish to fry than the treatment of lockpicks, so keep your eye on the ball.
Cool. Thank you very much for speaking. I think you've enlightened all of us on the legalities of lockpicking and lockpicks themselves.
Thank you very much, everyone, for showing up. Go forth, have this conversation, have fun with it, have as much patience as you can have with people that may not understand things that are obvious to you. That's what this is all about, is explaining to people that are outside the community and helping bring them in. So thank you very much for helping out with my project, and go forth, pick some locks.